Hi, everybody. Welcome back to our Legal Aid Services of Oklahoma Disaster Team podcast. My name is Arla Smith. I'm the Disaster Communications Manager here with Legal Aid Services of Oklahoma. Today, I have Isaac Morris and Jessica Foutch. They are the staff attorneys for our disaster team. Today, we're going to go ahead and talk about advanced directives, wills, and estate planning.
Hey, welcome back to What a Disaster, guys.
Yes, thanks for having me.
Thanks for having us, Arla. So just a little bit of background. We're going to talk about wills and things like that today, some estate planning. Sometimes people ask, how does this fit into our disaster realm? And what I like to tell people is in blue sky times when we're not actively responding to a disaster, one of the reasons we spend time doing wills and transfer on death deeds and planning is to help people. It's part of what we consider disaster preparedness, right?
Mm-hmm.
Right. Well, and then not just that, but it prepares you for not even when there's a disaster happening in general, because life happens. So just kind of being prepared for life in general is a good thing.
Right. Yeah. I mean, it's something, and again, in our last episode, talked about how we're on the disaster team, but we have other teams at Legal Aid. One particular elder law team, that does wills and other estate planning, advice and counseling. So I think, wills are important for really any area.
Yeah. No. So let's go ahead and get started here. What are some frequently asked questions we have with wills? Something along those lines.
I mean, I think the biggest one, I think one question's assumed, most people know that we need wills, or we need an estate planning document in place. And I think so the second necessary question is, what does that look like for me in my unique situation? Because we all have different property, different personal property, different, assets and different family dynamics. And that's a very fact specific question, one that, you need to speak to an attorney about so that we can weigh your options and do what's best for you financially as well as for your family.
Right. The only thing guaranteed in life are death and taxes. So everybody is going to die. So a will, and these planning things are really every person from young to old needs it. Especially as you age, you are going to be more likely to need it.
Right.
So like you said, the thing with pre-planning and wills and things like that is it is an individual approach. Every person's estate, the makeup of their property and how that property is titled is going to be different for everybody. Right. So I think, stepping back, what do we need to do? Look at that person's estate, look at that person's property. So usually people come in and they're going to ask, what kind of instruments do they need? What is it that I need? How can we do that? What does it cost? Who does a will benefit? I see a lot of these kind of questions.
Yeah.
And just stepping back as far as the cost, again, we're with Legal Aid Services of Oklahoma. Our firm does free civil legal services to low-income and senior Oklahomans. So a will can be costly. However, if you do meet our funding guidelines, our senior grants, we've got things, all kinds of different ways that we could fund getting you a will made.
Right.
So if that is something you do need help with and you do contact Legal Aid, ours would be free of charge. We do go, one spot that we frequent is the Claremore Senior Center, and I'm just going to give a plug here before we get too deep into it, because we've done some will signing clinics out there. So we really try and hit the senior population when it comes to this planning, and trying to make it affordable, because a lot of those seniors cannot afford $1,000, $2,000, $3,000 to pay someone for this document that we can do for free. And so who needs to have a will? Everybody does.
Another frequently asked question is, and it maybe it's a misconception, is that trusts are better than wills. As I get that question a lot. I mean, I hear you need a trust for tax consequences or what. And that's typically what I hear a lot is, it's better financially to have a trust. And of course, that question again varies on the individual situation. The tax consequences vary. There's a lot of that goes into it.
Absolutely.
But I think generally you need a will or you need an estate plan. You need a plan, documents in place to be able to pass your property to whom you wish upon your passing.
Right.
That's the general rule. And a will is a way to do that. There's several other ways to do it.
Right. There's transfer on death deeds,
Right.
which I think are great for legal purposes as far as transferring property. And if somebody has the assets such that they need a trust,
Right.
we're going to send them to somebody that specializes in estate planning. That's a little bit outside of what we handle for seniors and low income folks. So people that do have, multiple cars or homes that they want to keep in a trust, things like that we can refer you out to a private attorney to help with those.
Because I think if you have those assets, you're less likely to qualify for services anyway.
Right.
So that is ripe for referral.
Absolutely.
For a private attorney to take on that matter.
Well, and the Oklahoma Bar Association can actually help them also find an attorney as well.
Right. Yes.
Yes.
They have a directory for local attorneys, in your area that specialize in certain topics.
So a trust attorney could be found through Oklahoma Bar Association just to be able to kind of guide somebody if they're listening and has more than normal assets.
Yeah.
Okay. So normal things we ask is, what does a will do? What is a will?
Question, Arla. Isaac, you want to?
I mean, a will is a document that passes, like I said earlier, passes property to the people you wish, and it appoints somebody to oversee the distribution of your assets. You can also include, if you have minor children or adult children with special needs that need care throughout their life, you can appoint guardians for those kids and adults. I think generally that's kind of what it is.
What is the difference between a will, and I hear so often in our planning, you're shaking your head, you know exactly what I'm going to say, and a quote, living will that we hear people ask about.
Yeah, so a living will is, a similar to an advance directive. If you're in a end of life condition, where you're, vegetative state, coma, whatever the case may be, and you need to have answers to whether you want to be administered life-sustaining nutrition. That's a living will. That's for kind of end of life, not regarding property.
Right. So kind of a pre-death, right?
Yes.
I was thinking of the living will is when you're living, and then when your will is going to kick in when you die. So the provisions in your will don't really come to fruition until you have passed away.
Right.
I hear that so often, though. So thanks for kind of clarifying that. We also see a lot of power of attorneys. We work on those. And those are going to give somebody the ability to designate who they want to handle their affairs. We see medical power of attorneys, which is somebody to designate medical affairs, things like that. So, a will is going to be post-death distribution, a document that distributes your property, and things like that.
Yeah. One thing with wills that always keep in mind that they must be probated, which is a benefit because it means you're going to have judicial oversight of the distribution of your assets, which means it's going to ensure that the trustee, the executor, the person representative of the estate who has been appointed in the will is going to do what the will states. So you have that oversight, which is good and a benefit of a will, but it also means that it's a process and it takes time and it takes money to file probate and to go through that process.
So probate, you said the magic word. Tell me, and this is, I think, it's confusing to lay people. It's even confusing to me sometimes. When you say probate, every person that has a will, I just kind of want to throw out some clarification,
Right.
has to go and file that will in a probate action, correct?
Generally, yes.
To have it administered
Yes.
through the judicial process.
Right.
Now, it does, however, you hear people probating an estate. The will streamlines that process. So that's where we hear people talking about eating up the financial assets of the estate by and through the probate process. Here's the difference is when you have a will, that will tells the judge what that probate process is going to be, who is to oversee it as the executor or administrator, and then who are the heirs and the beneficiaries.
Right.
If you do not have a will, you still have to go to probate, but that's where you hear people talking about, like, we had to go to probate and probate the estate, i.e. meaning then it reverts from what you've written in your document to statutory guidelines set out by the state of Oklahoma. So whether you have a will or not, generally to administer that will, a probate is filed. But if you have a will, the probate process is not nearly as arduous, difficult. It's not going to cost you money and eat out of the estate. So that is the importance of a will. You still technically do have to file that probate, but there are guidelines to tell the court what to do so that it doesn't cost your money figuring out what to do.
Right. Because like you said, there are those default rules that the state of Oklahoma has adopted saying this is most likely what someone would want their property, who they want their property to pass to if they died without a will.
Right.
Whereas, so you can, with the will, you can say, no, I want this property to go to whom I want it to go to.
Right.
Irrespective of those general rules.
Yeah. In this process, we're trying to prevent government interference into your personal estate. And that is what having a will does. And so I think that's why it's important, because if you don't have that will, it reverts back to what does the government say my property who does,
Right, who does it go to? Yes.
Who does it go to?
Yeah, it gives you control over your assets.
Yes.
So since it gives control over the assets, it also does give control of who can be excluded from that will as well.
Right. Yeah, you can exclude people who generally have a right to take property under your estate, be it children, siblings. I mean, you can exclude folks in your will. You just have to be explicit in doing so.
Right.
And sorry, I do want to back up and say, this is not legal advice. This is just general information for you folks. This is very fact specific, individualized area planning is the area of the law. So, have questions, we're happy to answer those. But it's just general information.
Yes.
That's why I want to make that clarification.
Good caveat there.
Yeah, it does.
So, I think we had mentioned the estate, and probating the estate. So just picture the estate as like the big bubble around you and your property and everything. I mean, it's going to incorporate when somebody passes the quote estate that we're talking about is everything from the properties, their personal property, real property, vehicles, bank accounts. There's all kinds of things that go into the estate. So that's just generally the term we use to say everything that person owns and has control of.
So we've kind of mentioned at the beginning, talking about things as far as going through and saying, okay, this person has this control. We have a personal advocate who's going to be administering the estate. We have talked about, if somebody isn't included in the will. Are there any other factors that you can think of off the top of your head that might hinder a will just being thought out and thoroughly executed?
Well, there are some procedural requirements. I'm not sure if this is what you were trying to elicit, but as far as, you can't just, Jessica cannot just write a will generally and say, this is my will. There are signature requirements, whether I'm drafting it myself, which I had a huge debate with a gentleman one day at an outreach program over whether it is holographic or allographic. I need some feedback on that from the attorneys, guys, because I learned holographic my entire legal education, but I had an older gentleman in his 60s tell me, no, ma'am, it is holographic. And that's what we call a will when you're writing it out yourself. And so there are still requirements if I'm sitting down and writing my own will. So that's why it really is vital to contact an attorney, because they're going to know your signature requirements. If somebody's preparing a will for me, there are multiple statutory signature requirements. There's notarization requirements. There's witness requirements on who, how many, that they don't have interest in the estate.
Right.
So there's a number of little nuances to make sure that you do that will correctly, because if it's not done correctly, the probate court will not honor it if it is not a valid will. So signature requirements, things like that. So it's, again, why you want to get with an attorney is, how do I make it, and how do I make it legally binding?
Right.
And so that, again, is just a lot of signature requirements, things like that. So even if you want to write your own will, checking with an attorney to make sure you've done it right, signed it, that you've, handwritten it, et cetera, all these little requirements, just to check with an attorney to make sure you've done it right.
Yeah.
So, like, specific verbiage has to be in the will. Another thing that I've heard is that the witness signatures, because you have to have 2 witnesses sign your will, cannot be included in that will. Is that correct?
That is correct. Yeah. And I always recommend getting 3 witnesses, just because two is a requirement. 3 is best, I think, just because, one may pass, and, or they can't get in contact with that witness to, if they need to validate a will. So yeah, I think having 3 witnesses is good. And then as far as the no interest, I think just getting, people at a bank, or, wherever you go to notarize, just having anybody, that you don't really know, because even then that could be an issue. Even if they're not taking under the will, if you know them really well, then they could, there could be a reason to try to invalidate it.
And you mentioned notarized. So every will needs to be notarized, right?
Right.
So if they're writing a will themselves, even if they have the correct verbiage and they have the witnesses, they still need to have it looked at by an attorney and made sure it's notarized before.
So if they're doing a holographic will, which is, a handwritten will, it has to be in their own handwriting, signed and dated. That is the Oklahoma requirement.
Right.
However, it doesn't have to be notarized. I think some people have the misconception that it's better if it is notarized. Maybe it looks better to the judge, but those, just handwritten, signed, and dated is all you need under Oklahoma law for holographic will. But it's best to not do that, because there are additional requirements when you go to say, yes, this is their signature, this is their handwriting, this is what they wanted. So it's, again, best what Jessica said, you need an attorney to draft you a will. But in the unfortunate scenario where you have to just write a will, you can do that, but you must follow these requirements.
Right. Even as a kind of a silly one to me, and perhaps it's not legally silly, but just thinking about it, you can't print part of it. You cannot go, if you're writing a holographic will, you can't type half of it out on your computer, send it to your printer, add in, I want my dog to be next to me, and sign it, because the whole thing has to be in your hand. I mean, am I still right on that? I mean, so again, like preparing your own will holographically, you really do just want an attorney, because you can't even print half of it and handwrite half of it, because that could cause complications. So again, just very nuanced requirements. And so that's just why even a quick phone call, hey, let's and wills we can do pretty easily. So if people qualify for our services, that's something we can help with.
And so if we're not able to help with that, we could send it over to possibly like a pro bono attorney, which is an attorney who volunteers their time to help out a firm when there's an excessive amount of cases or something along those lines to complete that will with somebody, correct?
Correct. And I think at times it is worth noting there are certain circumstances where a will is not even necessary for someone's estate plan. If they have certain amount of assets that are handled by other instruments, devices, be it transfer on death deeds or payable on death for financial accounts, or your life insurance is
Yep.
handled by beneficiary designation. If all your property is going to pass according to your wishes by another document, you may not need a will, especially if your personal property, you don't feel that your heirs will have any dispute about it, or if you're already kind of dividing that up between your heirs. If that's the case, there are times when you don't need a will. So in that case, if if you don't qualify, then we could just give you some quick advice and to say, hey, do these things, or we could refer you to a pro bono attorney to take it.
Yeah. Okay. So yeah, that's a good point. There are other planning things. I'm going to say, I think you all need a will, but, there are plenty of other planning instruments, like you said, your life insurance. That is a matter of your beneficiary designation and passes, by and through that insurance company.
Right.
Your bank accounts, you can have a payable on death
Yeah.
or a joint account owner.
Yeah, I think last thing to say on that, on the beneficiaries for all those devices, I think it's always recommend to keep them current. If someone passes away, obviously update that.
Yes.
Have a contingent. So
Yeah.
have someone that you primarily want to take this asset, but then have in case they're unable or unwilling or they pass, have someone else who can take in their place.
Right.
That's kind of something else I would say.
What about, let me throw you a curveball here then. What about designating your child who happens to be a minor? What do you think about that?
Yeah, that's something you could do. I think it's then it becomes into like, if it goes into a trust for the child when they turn 18, it kind of further complicates it.
Not particularly advisable. Right.
Can, but not
You
advisable.
can, but
Yeah,
not
yeah.
advisable.
Yeah.
So you could do that, but with the guidance of an adult. I've seen that done.
Yeah, I mean, you could name the adult that is going to be the guardian of that child.
Right.
And they do have a duty to act in that child's best interest. So ideally, they would use those funds or whatever the asset is for the interest of the child.
Mhm.
So that is an option, but you need to make sure you're, carefully picking your guardians, So that's, and that's another topic, of course,
Man, we could
That
go,
goes to family
we
law.
could talk
Yeah.
about, but the thing with guardians too in your will to note is, yes, that you can designate, who you would want to be your minor child's guardian, things like that, and the court will consider it, but it's not a guaranteed. So like Isaac said, I mean, you would want to pick somebody
Right.
that the court would then turn around and approve. So, yes.
Yeah. And I think, I keep saying the last thing, but if we, like Jessica said, we all need wills. It's particularly on people's minds when they're older, but I think it should be on younger people's minds, especially ones who have minor children.
Yes.
So that you can, like we just said, you can appoint a guardian that you trust will raise them in a way that you would in your
Yes.
absence. So it's equally as important, if not more important.
Absolutely.
Because I think we'd all agree that our children are more important than our possessions. So it's more important to say, have a will to appoint a guardian to take care of them in your absence.
Absolutely.
Okay, and Jessica, you talked about advanced directives. Can you tell me what an advanced directive is?
So that is going to basically tell doctors, physicians, etc., about your medical care and what medical care you do and do not want to receive in the event that you're incapacitated.
If somebody goes into a coma and is unable to provide, answers to what they want done, then the advance directive would help. And the medical staff
Yes.
understand what they want.
It's an advanced directive. It's an advanced instructions on what they would want if they're unable to verbally tell you themselves.
Yes.
So it's typically, it's.
And it's really for just healthcare. I mean,
it is. And it's for the statute lays out 3 scenarios.
Mm-hmm.
I think the example most people give is, you're in a car accident and you're in a permanent vegetative state. You're not going to come back, unfortunately. And so then you can say, yes, I want to receive nutrition. I do not want to receive nutrition. I want to be an organ donor.
Mm-hmm.
All those things you can kind of designate in this document.
Right.
And then there's another, permanently unconscious state. There's
right.
And those are all detailed and complex. And again, that's where we can come in and kind of explain those and say, do you want this or not? And you can, and it's a 2 or 3 page document. It's really easy, signed, notarized, something that not a lot of people think about, I think, because we don't want to think about being incapacitated. No one does. So, something, we don't think about, but a good document to have, so that you're not putting your family, your loved ones in that scenario of saying, I think they would want this, or I think they would want that. So then no one's fighting.
Right. The advance directive says pull the plug. Let's pull the plug.
Even if you disagree, it's what they wanted.
It's what they have determined. Yes. I mean, it really is kind of that detailed about, do I want artificial nutrition? Do I want artificial sustaining of life during an incapacitated time?
Right.
That's terminal, right?
Yeah.
Not you've had a wreck and you're coming back and, they're operating. So a terminal condition, like you were saying.
Right. And I think in the alternative not the alternative, but if it's not terminal, that's when you mentioned a medical power of attorney, that's when, you're not permanently incapacitated, or you won't be permanently incapacitated, but you are at this moment.
Yes.
You can designate someone to make those decisions while you're incapacitated. And then when you are competent, then you resume the authority to make your own decisions.
And this just brings me to the point that's why it's important to talk to an attorney. I mean, we've got so many documents before death, after death, that really it takes a number of documents to really get you fully prepared for all situations. I mean, we've got POAs, or power of attorneys, medical power of attorneys that you just mentioned, advance directives. So all these in combination go to your whole estate plan.
Okay, so basically scale 1 to 10, everybody recommends a 10 to make sure you're doing your will, your advance directive. If you want a medical power of attorney, am I on board with that?
Yes.
Yeah.
And I think to our earlier podcast, we talked about important documents. These are those important documents that you would put in a safe, in a freezer, if you have a safe. These are important documents that, typically, your agent that you've designated in your power of attorney would have a copy of that. But it's good to have multiple copies of these documents and to keep some in your safe. So
I'm just going to highlight from the last podcast. Man, putting your stuff in your freezer.
Yeah.
I love it.
It works.
It does.
I'm going to start using that. So just a reminder out there, folks, if you don't have a water and fireproof safe, put your important documents in your freezer.
In a Ziploc bag first.
In a Ziploc bag in your freezer.
Yes.
I love it.
And check out our previous podcast for kind of more information on that and how else we can help with that.
Yes.
Okay, so kind of following up, is there anything that you can think of that maybe we haven't discussed or talked about in regards to, getting a will set up, getting an advance directive, power of attorney? We talked about trust.
I think we had kind of talked on this a little bit of if I don't have one, what happens?
Yeah.
The Oklahoma laws are going to determine what happened to your property. So if you don't have a will, there's a statute that lays out, if you have kids, then these people take. If you don't have kids, these people take. If you're married, the spouse gets this amount. So If you don't have one, it's going to revert to the government determining what
Yep.
happens to your property. Um,
So I have a question on that. Is there, and this may be a curveball for you, is there a limit to how much a person can have in possessions that requires it to go to maybe probate? Or is there a limit of saying, they only have a car and just their personal possessions, and that keeps it out of going to probate because maybe they were renting a home or they were staying in an assisted living facility or something along those lines?
So there are planning. I mean, I think it's different with the planning aspect
Yes.
versus post.
Yes. Yeah. So I guess example is maybe a better way to say it is if you just have a car and a house, or even if in your scenario you're renting, so you just have a car, if you've already designated who that needs to go to upon your passing, but you still have a will to say it needs to go to this person, then that's going to pass outside of the will. So you necessarily wouldn't need to go to probate for that.
Right.
It's, aside from, debts and other taxes and things, and that's a different scenario. But generally, yes, there are times when you would need to probate the will. Second answer, coming back to is there are statutory
Small estate affidavits. Yeah.
So if your estate's under $50,000, you can do a small estate affidavit, which is a much more streamlined process than going through probate. And there's even summary administration for probate. So if it's under, I think, $250,000.
Yeah.
I have to check the numbers. But there are certain kind of layers to it of probate.
So precisely the small estate affidavit, but again, that's post death. So that is something as a last resort for your heirs, and that's where I got kind of sidetracked, is a will. These documents you're going to do before death.
Right.
These are a pre-planning. The small estate affidavit is an option post-death for your heirs. It's not really an option for you to plan, but in the event you pass without the proper things, there are some documents that we can prepare that help you administer a estate if there are not a lot of assets.
Okay.
Or
if something wasn't included because it was maybe recently purchased in the will, could that also fall into that line?
Well, I think that would probably go into the residual of the will, right?
That would go into a clause where just property that isn't explicitly stated in the will or obtained after the will. It goes into this
like a residual.
Yeah. This
everything remaining.
Pot. Yeah. This fictional pot of assets.
Yes.
That
may or may not exist.
may or may not exist, and that you have to put someone to receive.
Yes. And usually it's their main heir when we, prepare them. Is most of the time the main heir will get they call it the residue, right?
Residue, the remaining property.
So the importance of updating your will if you purchase new property, right?
Very important to update your will.
Yes. Yeah. Yes, absolutely.
And I think that is, I never want to discourage people from getting wills, but I think that is a downside to a will, is having to always update it. One, and two, the expense and time for a probate. Again, that's why it's good to talk to an attorney to be able to say, is this really right for me?
Right.
Is there other documents that I can take advantage of to better pass my property to my heirs quicker and much more cost effective?
And that could be the transfer on death deed.
Right.
Correct?
Okay. Payable on death for financial accounts, transfer on death for even your motor vehicles. If anything is kind of handled by a title or a deed, you can transfer that upon your passing to somebody or to several people.
Anytime that you have any questions on anything for wills or advanced directives, estate planning, we have all of that information available on www.oklahomadisasterlegalhelp.org. So that you can go to that website, you can go to specific topic information under our all topics section and be able to go through all of that, review it. There's printable documentation on there. There's just a whole bunch of information to help with disasters or anything disaster related. So please feel free to visit that. And if there is nothing else for you all, then I hope everybody has a wonderful day.
Yes. Thanks for having us again.
Yeah, thank you.
Thank you.